Oh, why are you here so early? Class doesn't start for another half an hour.
Well, I've been struggling with this problem question and I don't know how to answer it, and I thought I could get some help from you.
Have you tried using the IRAC structure?
I think you mentioned it a couple of weeks ago, but I don't actually remember how it works.
No problem, I can go through it again. Let's go through what each of the letters stand for. The I stands for issue. This is where you give a brief statement of the legal issue. The R stands for rule. This is where you give an outline of the relevant law. The A stands for application. This is where you apply the law to the facts. And finally, the C stands for conclusion, where you'll provide a tentative conclusion outlining your answer to the questions.
Wow, splitting my answer up into those sections will really make it so much clearer.
Some people prefer stating material facts prior to the legal issues, but this depends on your preferences or whether, for example, the facts are more complicated or confusing, that clearing up your understanding of them early on will be a good indication to the marker that you have read through the facts thoroughly.
In the first part, the issue, should I be recounting the whole of the fact scenario?
No, you should be very brief and only include what issues and facts are completely necessary. You can generally assume that the marker is aware of your facts. Of course, if the question is more theoretical or involves discussion of policy, this part of your response may be longer.
How about with the rules section? How much of the legislation should I be quoting?
This section should not be too long either. It should only include the law that is necessary to adequately answer the question. You can also include a little discussion of the law where it is tedious, or if the question is asking your opinion on the law.
So I'm guessing the application section is like the meaty part of the answer?
Correct. This section scores the most marks and it is where markers will pay the most attention. You should apply the law to the facts in this part and analyse what this means for the question you have been asked. Here are some things you might want to consider. How does the law apply? What facts are important here? Do some of the cases in your readings have similar facts to your problem question? Is the law clear? Is it unclear? Should I discuss this? Will it materially impact my answer? Am I answering the question? Or is my discussion irrelevant? Are there any relevant defences, for example, self-defence for murder, or other relevant factors, for example, contributory negligence for tort? A really good tip is to give the facts of similar cases. You could argue either way regarding the ruling of the case. Either the facts are so similar as to justify the court ruling the same way for your problem question, or there are sufficient differences to justify a different outcome. However, you should resist the urge to go overboard in this area. The lecturers are likely to include red herrings in the facts, which might encourage you to explore irrelevant avenues of argument.
Thanks, that was actually really helpful. All we have to do now is finish with a strong conclusion?
Yes, your conclusion should be tentative to reflect that this is the best conclusion you can make based on the facts. Keep in mind that the conclusion is generally not as important as the application. So long as your conclusion is derived logically from your arguments, your marks should be decent. Finally, remember to answer the question.
Hope this helps you guys, and good luck for your exams.